Hello and welcome. We're pleased that you've joined us for today's session, Navigating Increased Scrutiny for Healthcare Deals in 2024. Before we begin, I'm going to play our housekeeping video.
Welcome, and thank you for viewing our webcast series. Before we begin, please keep the following in mind. You can customize how you view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can adjust window size and placement or enter full screen mode using the controls at the top right of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons that relate to a different aspect of our session. You can download a PDF of today's slides from the Slide Deck and Handouts widget. You can ask questions by typing in the Q&A window and clicking Submit. We'll do our best to answer all questions or follow up via email. If you experience technical difficulty, refresh your browser by hitting the F5 key. This presentation is not legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
Welcome, everybody.
All right, and now I would like to, oh, sorry, Eric. I was going to say I would like to hand it over to Eric, but take it away.
Great. Thank you so much. Always eager to get started. So I'm Eric Klein. I lead the National Healthcare team at Sheppard Mullin. Very glad that all of you can be here today. We've got over 500 folks on the webinar with us. Do feel free over the course of the hour today to go ahead and to type in your questions. We'll do our best to get to them as possible. With me today, we've got Bill Barcellona, Executive Vice President of America's Physician Groups, one of the nation's leading physician organizations. And then we also have the leader of the healthcare practice at Moss Adams, Chris Pritchard, the leader of the Moss Adams strategy and integration group on the consulting side, and that's Karl Rebay. Also with me are two of my partners, John Carroll, who is a healthcare antitrust partner based in our Washington, D.C. office, and then additionally, Jordan Grushkin, a partner in our Century City office, and he's a healthcare transactional partner, and he also leads the firm's OCA, Office of Healthcare Affordability, our gift from California that we'll be talking about today. Now, it's very interesting what we're seeing out there in the industry. You know, when we think about trying to do transactions today, it's hard because we're seeing continued increases in healthcare costs. We're seeing continued trends of consolidation as the big get bigger. And today, literally, we are seeing announcements and changes every single day. And it's because we're seeing so much pressure financially in the system, but also because we're seeing quite a bit of confusion, both between the federal and state levels, but also between the federal agencies themselves. CMS tells us that by 2030, all of Medicare has to be in value-based care arrangements. At the same time, the Federal Trade Commission, the Department of Justice, are worried about too much consolidation, too much scale, too much market power. But how do you go ahead and do population health management without scale and without the investment in infrastructure and IT that's necessary to do that? These are difficult times. Just look at the hospital sector. You know, we're seeing quite a number of health systems that are healthy and doing well, but of the 5,000 hospitals, and by the way, there's a little bit over 5,000 ambulatory surgery centers out there as well today, more than half of those hospitals are break even or are at a loss, and many of those hospitals are really financially distressed and are going to find themselves under significant challenge. We're seeing quite a bit of that challenge as we look at the next slide, right, Jordan? Especially in mergers and acquisitions these days, right?
Yeah, absolutely. You know, looking at Kaufman Hall's January Hospital and Health System Review Report, I mean, it highlighted a number of troubling metrics. Last year, 2023, nearly a third of hospital mergers and acquisitions were driven by financial distress, and that's a huge jump compared to the previous 4 years. It was actually trending downwards between 2019 and 2022, and then you had this huge spike last year. I also thought it was interesting to note that the average size over the past 2 years of a financially distressed partner was over $160 million in annual revenue. So it's not just small hospitals and systems that are experiencing challenges. And as you previewed before, on the other hand, you have a lot of new developments related to government review and approval of transactions and similar transactional hurdles. both on the state and federal side. And some of these represent dramatic overhauls and significant headways to get a deal actually across the finish line. John will talk about a few of the key highlights on the federal side. Bill, the Moss Adams team, and I will talk about some of the notable developments on the state side. And as John will note on the next slide, some of these developments have driven, in whole or in part, some notable deals already to fail or be significantly delayed. So we're going to talk about some of these new hurdles and challenges facing those in the healthcare space and what our teams believe folks should be aware of regarding these challenges as they engage in strategic planning and consideration of deals.
Thanks so much, Jordan. As Jordan previewed, a number of transactions have been abandoned or or undergoing tremendous uncertainty as to whether they get to close in light of challenges from federal authorities and from state regulatory regimes as well. And Novant, I believe, is still being litigated, but to focus just a bit on at the federal level on the Muir tenant deal, we see that, there was a transaction, I think, that most of us in the antitrust community, and we were not involved in it, but most of us in the antitrust community were somewhat surprised was challenged. And, the important context here is when a transaction is going to be, a hospital merger transaction in particular, is going to be litigated or challenged by the Federal Trade Commission, and in this instance, in cooperation with the California Department of Justice, these are tremendously burdensome, expensive, and uncertain pieces of litigation. And so to try a hospital merger case, even if you think the facts are on your side, given the financial constraints Jordan and Eric just described that systems are undergoing, many systems, even if they fully believe that a merger is pro-competitive and does not violate the antitrust laws, simply don't want to undertake the financial risk and the uncertainty over months and months of litigation to try to overcome in court objections from the Federal Trade Commission. And so we do see instances, particularly over the last few years, where hospital mergers, again in particular, have been abandoned in the face of challenge. And most recently, this was the Muir tenant deal in Northern California. And with that, I'll turn it back over to Eric for, I think, our first polling question on the next slide.
That's right. And so that our accounting friends on the call can get professional education credit, we'll have a few of these over the course of this. So just go ahead and let us know whether your organization is currently considering transaction 2024. All responses, by the way, are confidential. So A, yes; B, no; C, not sure or not applicable. And we could also put in a D, which is get back to me later, please. But let's go ahead and just do A, B, or C right now. So if you want to go ahead and hit that, we'll take a look and see what everybody thinks, then we'll move on with this. Now, one of the things that's interesting is that we're continuing to see a pretty good pace of transactions. As we're waiting for polling results, 2023 versus 2022, hospital system transactions were up by 21%, but physician organization transactions were down. That being said, we saw a large amount of activity still by the strategic investors, health plans, health systems, and much less activity by private equity. Okay, so here's where we are. We've got basically about a third each where folks are looking at transactions and are looking at the different possibilities here. So let's go on to the next slide here. And let me turn it back here to you, John. Really, a lot of things happening at the federal level these days, right?
There are, Eric, absolutely. In fact, just today, two things to report on before I even get into the content on the slides. The FTC and Department of Justice and Department of Health and Human Services announced just a few hours ago that they are launching, and I'm quoting from the FTC's press release here, a cross-government inquiry on the impact of, quote, corporate greed in healthcare. So I guess greed is no longer good, like the 1980s, to borrow from Eric, something that you said earlier. The FTC, DOJ, and HHS are going to be putting out, again, launching an initiative to really examine what they describe as the corporate takeover of the practice of medicine. So stay tuned on that front. The other thing, before I get into the framework, which I'll do just very briefly, is this afternoon, the FTC is hosting a workshop on the impacts of the private equity industry on healthcare. And that's going to be several hours, going on for several hours this afternoon, Eastern Standard Time. It's going to be run by the current chair of the Federal Trade Commission, Lena Khan, and is going to feature a number of other folks from the FTC, some academics, and I think just very few folks actually from the industry. So stay tuned on that front in terms of the workshop. Quick pitch for our blog. We will be blogging about that at Sheppard Mullin on the antitrust blog and on the healthcare blog as well. And we hope to have something out tomorrow that describes and provides an overview of the private equity FTC workshop. Okay, so turning to the traditional framework in healthcare transactions, the way I like to think about this, or the way I think most antitrust lawyers like to think about this is sort of what the world had looked like for the past really several decades when it comes to healthcare antitrust enforcement, which is relatively aggressive federal agencies at the FTC and DOJ, but also a relatively predictable and certain framework for the types of transactions that one would expect to be challenged or at least significantly investigated. And here are the key indicia. The antitrust law is designed to protect competition, not competitors. And in competition, really the price effects or the consumer welfare or the welfare of patients as a result of potential action in the healthcare space. The key types of competitive harm, increasing prices, like I just said, kicking out competitors or foreclosing competition, things that are relatively easy to ascertain and to study in terms of examining transactions. And then when we turn to the agencies, we see really how I like to think, or how we like to think about the antitrust laws, particularly in healthcare, which is the law itself is pretty open-ended and subject to a lot of different interpretation. And when it comes to mergers and acquisitions, Section 7 of the Clayton Act prohibits deals where the effect would be to substantially lessen competition or tend to create a monopoly. That has meaning, but there's a lot of room for interpretation. And how do the FTC and DOJ, how have they historically interpreted what that means? What types of deals violate Section 7 of the Clayton Act? They've done that through their pronouncements on their interpretation of the statute, which is in the merger guidelines. The merger guidelines, which have been updated, roughly every, 8 to 15 years, sometimes surviving administrations and sometimes not, and most recently being updated just at the end of last year. Next slide, please. So that traditional framework that I just described is undergoing a substantial overhaul. As I mentioned just on the title slide here, we have two pieces of news just today in terms of how the FTC, DOJ, and more importantly, other federal agencies are tackling what they view to be a competition problem, a competition enforcement problem in the U.S. And there's a lot to be said about this, but I think one important way to be thinking about this big picture and how the government thinks about antitrust enforcement is a whole of government approach. It's not just about the FTC. It's not just about the DOJ. It's about other agencies in tackling, again, what the Biden administration said during the incoming Biden administration said during the campaign and has had said since then, which is a problem of too much concentration in certain industries in the U.S. and healthcare being chief among them. So how has this been overhauled, that traditional framework? First of all, as I mentioned, how the agencies interpret the law is really important here. Section 7 in the Clayton Act doesn't really say a whole lot about the types of deals that would raise concerns, just simply whether they substantially lessen competition. The merger guidelines have outlined historically exactly how the agencies look at deals, and they were recently updated, in fact, substantially overhauled by the FTC and DOJ, having been finalized at the end of last year. There are many things to talk about in terms of what the guidelines say about the antitrust laws. And it's important to note that while they reflect current agency thinking, they're not law. And at some point, I think most would agree, likely will be challenged in court by parties seeking to get their merger effectuated and be able to close that deal. So there's a lot to talk about here, but really just want to highlight one thing, which is I consider, and many others consider to be the most significant change in merger enforcement, which is the emphasis on market share, and in particular, the concept that 30% market share is considered dominant. This is something that does have, to give the agencies credit, some basis in the case law, but is a substantial departure from how the FTC and DOJ have historically and in recent history examined what they consider to be a dominant presence. In fact, there's a polling question coming up, sneak preview, as to whether folks on this webinar consider having 30% market share to be dominant. So how are they actually going to enforce these things? Or how are the government agencies going to enforce this mandate and enforce these new standards with respect to merger review? That's on the next slide. They're going to get a lot more information. The agencies have been overhauling not just the substantive framework by which they evaluate potential transactions, but the type of information and the amount of information that they are seeking in the merger review process. So in short, since 1976, there's been this system for transactions of a certain size and a certain structure, whereby the parties are obligated to provide certain information to the FTC and DOJ and wait 30 calendar days before they can close the deal unless the agencies have concerns. That's the HSR process. Many people, I'm sure, on this webinar have been through this process. It can have some complexity, but I think it's fair to say HSR filings don't require an overwhelming amount of information, but hopefully and presumably it's been the case, enough information for the agencies to evaluate the transaction. Well, these regulations and rules about the information that must be provided are also undergoing a substantial overhaul. While not finalized, there are new HSR rules that have been proposed and we anticipate will be finalized later this year that really change the entire system by which parties have to provide information to the government to get their deal cleared or approved. These include literally every draft of agreements exchanged between and among the parties. Significant details about investments and directors in the PE context. And what these lead to, in our view, is more of a basis for the FTC and DOJ to slow down and potentially even kill deals as they overwhelm them with information requests and some degree of uncertainty. Next slide, please. So in addition to giving more rules, the FTC and DOJ have also taken away, and they've taken away in the form of the withdrawal of substantial amount of healthcare enforcement guidance. So outside of the traditional merger and acquisition framework, the FTC and DOJ have provided hundreds of pages of very detailed guidance starting in 1993, but really starting in earnest in 1996 with the healthcare statements. These pieces of guidance cover information exchanges, clinically integrated networks, rural hospital transactions, group purchasing, all the types of things that folks in the industry want to enter into in terms of collaborative activity, yet also want to make sure that don't run afoul of the antitrust laws. Well, just a few months ago, starting with the DOJ, actually about a year ago, and then a few months later, the FTC, all of that guidance has been withdrawn. And what we have left are some enforcement actions by the FTC and DOJ. We have the case law in this arena. There's not much, frankly. And we have, some business review letters and advisory opinions by the FTC and DOJ where they've blessed certain activities. But at the end of the day, there is much more uncertainty in terms of how the FTC and DOJ think about, outside of, again, just the merger context, collaborative activities in the healthcare sector, which is causing, we just add this to the pile in terms of creating more uncertainty from a compliance perspective as systems and other providers explore potential arrangements. With that, I believe I'm turning it back to Eric for yet another polling question.
Great, thanks, John. So here's the question: do you consider 30% market share to be dominant for the way in which you're working in the market? A, yes; B, no; or C, not sure, not applicable. And while we're doing that, I one of the questions that came in from our audience members asked the question, is it just me or does it seem like payers have a lot less scrutiny for horizontal and vertical transactions like this than providers and health systems do? Let me take that first and I'll hand that to you, John, quickly while we're waiting for our poll results, because many of you have seen the Wall Street Journal article that was published this past week about the Department of Justice Antitrust Division investigating United Healthcare and Optum, looking at the way in which United Healthcare, through vertical integration with Optum, allegedly may be taking advantage of market power to go ahead and to increase costs for their competitors, to potentially go ahead and to cause increases in Medicare Advantage risk adjustment scores, and to potentially avoid the 85% MLR rule. John, what are your thoughts?
Well, I think there are a number of ways to look at this, Eric. And as you know, we get this question a lot from providers in particular, right? And our clients who say, wait a minute, what about the payers? Why is all the focus on providers? The short answer being, I guess, probably a little too fair to FTC and DOJ is, well, there are a lot more hospital mergers than there are payer mergers. And the last two really significant strategic payer transactions, just about 9 or 10 years ago, I believe, were both blocked by DOJ. Yet hospital mergers, strategic mergers, continue sort of unabated. And so there's more simply for FTC to challenge. The other part of this that's a little bit more nuanced, and I'll try to be brief here, but from an antitrust perspective, thinking about mergers and the effect on consumers is sometimes overly simplified, frankly, by the enforcers. And they often think in terms of buyers and sellers and concern themselves with the impact on patients, consumers as the purchasers of these services, and as providers as the seller of these services. So within that traditional antitrust framework, it's easier in some ways and more intuitive as an antitrust enforcer to focus on providers and the impact that the prices they charge may have on consumers. And because they can't poll or survey or investigate the impact on patients at the actual patient level, payers are largely considered a proxy for potential consumer harm. And so necessarily when you're looking at provider deals, the question becomes, well, what is the impact on their negotiating leverage with commercial payers? And that's, I think, somewhat at least somewhat explains, why there's so much focus on harm, competitive harm through provider mergers, and in particular, the impact on payers.
Great, thanks, John. So the other thing too is that the Department of Justice, which is in charge of the payer side of the house, has been less successful in litigation against the payers than the Federal Trade Commission has been vis-a-vis hospital systems and physician organizations. For example, the United Healthcare change litigation was not resolved successfully. So let's take a look here. So we've got 42% thinking that 30% of market share is considered to be dominant. And so it very much accords with the guidance. David Joyner, who leads Hill Physicians in the Bay Area, made the good point on the Q&A that 30% market share really depends on market definition. That's a great point, because at the end of the day, there are things you can do ahead of time before you go in to the Federal Trade Commission, the Department of Justice, that can help define your market share, that can help align you with payers so that you get a better reception from the payers. And also you can do economic work that helps the FTC or the DOJ to see the market the way that you see them. So as we go on to the next slide here, we're going to start to talk now about what's happening at the state level, because the federal level, while confusing, is nothing at all compared to the state level right now, where we're seeing a wave that's really changing as we go to the next slide here, the way that we've seen enforcement at the state level before. All right, so let's take this away.
All right, thanks, Eric. State approaches to cost control are the second tier of enforcement below the federal level, and we're seeing a lot of activity here. 13 states have transaction oversight models. Jordan and John are going to talk about that shortly. 9 states have cost growth cap models. We'll be talking in particular about California's OCA model as that an example. Let's go to the next slide. So statewide cost growth percentage approaches like OCA and these other states try to impose a statewide cap based on a selected index. It could be median family income, which is what California is proposing. Other states have used other economic indicators like state domestic product. These caps are statewide. They can be drilled down into sectoral, for example, the hospital community, the provider group community. And the adopted ranges have run anywhere from a low of 2.8 to a high of 4.3 across these different states. And over time, California is proposing 3% right now. It may or may not adopt that percentage rate. But recently, since we've moved into the COVID era, we've been in an inflationary trend of about 5% for a lot of these healthcare entities. So this creates some tension. Let's go to the next slide. So an overhaul of states' merger review framework. One thing I wanted to mention here is that there's been a new wave of National Council on State Legislators Model Act legislation around preventing or overseeing different types of private equity or other types of mergers. California is entertaining a new bill that gives our Attorney General that power. So is Indiana, the first red state among all of these, to look at this. And so this is an interesting trend as well. And let's go to the next slide.
All right. So one of the questions here is whether regulatory issues are a key consideration for your organization when you're selecting a potential transaction partner. A for yes, B for no. So when we think about what's happening here, we're seeing a trend that has been started a little while ago, but it's been accelerating. You know, Massachusetts put in their merger review and cost control statute a number of years back, but in the past couple of years, we've seen multiple states jump in very quickly. Bill, why did this California bill come into play? Who was behind that at that point? Was it the governor's office? Was it the legislature? How did that work?
It was a combined effort between the governor and the legislature. Was primarily sponsored by one large health plan, by labor, organized labor, and by the employer community. Those were the key drivers for this legislation.
So the thought was that by putting this in place, it would retard the purchase of physician groups by hospitals or by private equity. Is that correct?
Yes.
All right. So let's take a look at our poll results here. Definitely yes, 63%. Nothing further to discuss about that. So let's go on and let's talk about OCA, which is the new four-letter swear word in California. I'm so sorry. It's the new four-letter word that denotes the agency that will be conducting reviews of California transactions. Jordan, would you like to dig me out of my hole here?
Definitely. California it's a good example of what Bill was reviewing on the previous slides, because it has both a merger control aspect to it as well as a cost target enforcement regime. So we'll get into both. Amy, if you could go to the next slide. Yeah, so this is just sort of a very high-level overview of the rollout of this law. It was passed in 2022. Late last year, they finalized the regulations that govern the merger control, or CMIR, process that we're going to talk about in just a minute or two. And now that we're in 2024, actually in less than a month, applicable transactions are going to have to go through the CMIR process to be able to close a transaction. So that's happening starting April 1st. Beyond that, actually later this year, payers are supposed to start reporting data on total expenditures, and this is going to help OCA essentially come up with their cost target methodology. Next year, 2025, there will be a non-enforceable cost target, and this will be a statewide cost target. 2026, there will be the first enforceable statewide cost target, and then in 2027 and beyond, OCA is going to develop, as again Bill previewed, sector-specific cost growth targets, potentially geographic specific cost growth targets, and potentially cost growth targets on individual entities. So if you can go to the next slide, we'll go into who does this apply to. In California, they are called healthcare entities, and these include a large group of providers, so large physician groups, hospitals, outpatient clinics. These include payers. These also include fully integrated delivery systems. So those are the entities that are subject to the cost targets. And for certain of these healthcare entities, they are also going to be subject to this CMIR cost and market impact review filing requirement. So you have to hit either a materiality threshold or a geographical threshold to be applicable. In terms of the transactions that these catch, these are transactions with a pretty low materiality threshold, $25 million, 25% changes of ownership or control, 25% asset transfers. And these are just a number of the triggers. I believe there are about 8 separate transactional triggers. So that's essentially who this applies to. Chris, Karl, do you want to get into just a little bit of sort of the timing consideration, what actually goes into a filing?
Yeah, so Jordan, thank you. I'll talk a little bit more about what's required in the filing, at least the notice to OCA related to a particular transaction. It really requires extensive disclosures, primarily related to, but not exclusive to, narrative descriptions of the transactions and the parties looking to do the transaction, some draft definitive agreements of the transactions, certified or audited financial statements for the last 3 years, among other things. The filings are considered public unless they're marked confidential and treatment is accepted by the department. But your timeline is told. While OCA awaits more information related to from the parties to review the transaction, and or if it's been being reviewed by another state agency, your timeline is told and not progressing. So part of the strategy here would also make sure you're filing complete applications so that the timeline is moving forward quicker than what you see here. There is an option for distress situations or severe financial distress situations. You can request an expedited review for those types of transactions. But also OCA has the ability to refer your transaction to other state agencies and vice versa, which also may have implications on your timeline. On the next slide are some additional items to consider in your filing. Primarily, they relate to things that you need to consider associated with either narratives or market study or impact studies associated with the effect of the transaction on the market, either from a cost perspective, from a competition perspective, and or access to care. These are all items that will need to be documented and discussed in the application process as well. Again, we talked about the tolling, so you want to do everything you can to have a very complete and well thought out application. But also, please understand that the state's review process, the cost of that is borne by the transacting parties, which can be reasonably significant depending on the size of the deal. So those are items that would affect some of the timeline. I think on the next slide, you have a little bit more detail, and I'll turn it back to you, Jordan.
Yeah, so on the timeline, just to give a very high-level overview. So this is an example where you need to submit your transaction 90 days prior to closing, and then OCA essentially has 45 days to decide whether or not to grant a waiver. But if they don't grant a waiver, and again, as Chris mentioned, the possibility of tolling and really extending out the timeline, you're looking at a timeline of potentially 9 or more months going through this process. So this is pretty significant in California. So that's essentially OCA. If you go on to the next slide, we'll go just quickly through a couple of other state examples. So in Oregon,
and Jordan, before we go into Oregon, though, just a couple quick notes for California, because I think it's important for folks to understand this. The rules that were finally adopted did drop out management service organizations. So an MSO is not necessarily involved unless it's got control over a healthcare entity. And then at that point, it may come in. So make sure you talk to somebody really smart like Jordan when you're looking at this, because there's a number of sectors that are not listed in the review. So for example, if you're looking at something like hospice or home health, it does not appear to be listed. And there are other sectors as well. So do not despair, at least before you talk to your lawyer or your accountant or your consultant. The second thing I'd mention is we also don't yet have a lot of guidance as to how the various state agencies play together. So I'll give an example here, and then this is very similar to what we're going to see in other states as well. So if the Department of Managed Healthcare, which regulates HMOs or Knox-Keene plans here in California, basically managed care plans, if there's a Knox-Keene plan involved in transaction, and then you also have a hospital or you've got a physician group or other healthcare entities that are part of the overall organization, so you've got basically multiple modalities through a vertically integrated approach. In that situation, what you would see is you would see potentially part of the transaction being reviewed by the Department of Managed Healthcare as to the health plan, and the rest of the transaction being reviewed by OCA. And the timelines are different. The opportunity for regulatory positions are different. The regulatory review standards are different, et cetera. So we would think it would make sense for the Department of Managed Healthcare to take charge of any transaction that has a health plan involved, because under the 2019 merger review statute that the Department of Managed Healthcare implemented has been successfully utilizing, that allows for a holistic view and for a public hearing if necessary for a major transaction. But it's an interesting question because New York, for example, which also adopted a notice law for merger review, they have multiple agencies that govern New York healthcare entities, and sometimes it can take, again, 9 to 12 months for a normal transaction in New York to get approval from the Department of Health, Department of Education, et cetera. And so this is a really interesting question we're going to see. The other question, Jordan, is that came from the audience is, in California, are ambulatory surgery centers, ASCs, included as healthcare entities?
They are indeed. So, again, it's subject to, meeting a materiality threshold that'll, be necessary to figure out before, deciding whether or not you need to do a CMIR filing. But ASCs are one of the listed providers that are considered healthcare entities.
All right, so let's take a look at Oregon, because that's a quicker process, but still a very interesting and complex process.
Yeah. So just quickly on Oregon, this is again framed as a merger control law by the Oregon Health Authority. You'll see again, the scope includes a pretty low materiality threshold. 25 million in terms of a transaction with a $10 million healthcare entity. Healthcare entities include providers, insurers, and as Eric mentioned, MSOs. So those are captured in Oregon. Parties must file prior written notice, and this agency, unlike technically in California, it actually has the authority to affirmatively approve or disapprove of the deal. There's an initial review period of 30 days, but if OHA elects to conduct a comprehensive review, this process can drag out much longer, approximately 6 months. So that just gives you a flavor of what Oregon is doing on this. And if you go on to the next slide, a little bit different, but there's also new movement in the state legislature. So different from a merger control law, Oregon is considering a bill that, if enacted, targets one of the more common investment structures in healthcare, the PC MSO model, or friendly PC or captive PC. So if enacted, it would place substantial restrictions on the ability on the nominee shareholder of a professional corporation. It would also have substantial restrictions on the ability of an MSO entity to make succession decisions. So depending on how this shakes out, whether or not it gets enacted, what the final language is, the traditional friendly PC MSO model may or may not be a viable structuring option depending on the parties involved in the deal aspects. So it's certainly something we're tracking and folks considering transactions in that state to be aware of. If you
Hey,
go
Jordan.
to the next slide.
And Jordan, before we jump to New York, there was a question from the audience that said that Oregon's also looking at cost targets, but holding primary care accountable for cost growth that is beyond their control. Why would the state do that, and is that common in other states? Let me throw that question to Chris and Karl, because Moss Adams does a lot of work in Oregon, right?
Karl?
So I don't think we can hear from Karl right now. So basically, Chris, wouldn't you agree that in Oregon, basically OHA is still looking at each entity as being responsible for costs and for their part of the system, even though they're not necessarily in control of the rest of the system. Isn't that correct?
With that makes sense.
So, Jordan, let's take a look at New York and see what they're doing here.
Yeah, so New York's taken on balance, I would say a somewhat lighter approach than compared to the California and Oregon examples. It's a prior written notice, framework. You need basically for applicable parties, which include, it's really targeting physician practices and MSOs. They're required to give prior written notice to the New York Department of Health for material transactions. This includes M&A activity, joint ventures, affiliations, and similar transactions. There is a materiality threshold where if you're under 25 million, that's considered an immaterial transaction. But again, $25 million, threshold quite low for healthcare transactions. So that's essentially what it looks like in New York. And then just to finish this out, the next slide, Illinois. Illinois, again, sort of similar in scope to New York. This is prior written notice here to the Illinois Attorney General. The covered entities include hospitals, ASCs, medical groups, IPAs, ACOs, just to name a few. Transactions include mergers, acquisitions, contractual affiliations. And then for non-HSR transactions, what's important to know here is that the state attorney general may require additional information in terms of the filing, and closing is not permitted until 30 days after it deems there being substantial compliance with that additional filing request. So again, potential to really, really drag out the timeline. And then just to note one other thing, we've kind of listed a handful of states that are notable. These tend to be, sort of coastal states, maybe more liberal on the political spectrum. But as Bill previewed before, we're actually seeing, similar activity, starting in red states. So Indiana last week just proposed a bill which, if enacted, would require 90 days prior written notice for certain healthcare transactions, and they have a materiality threshold of $10 million. So even lower than what we see in OCA in California and in New York. So these are changing every single day. We don't think that this activity is going to stop. So folks considering transactions in virtually any state are going to should almost expect that even if there isn't a law on the books, there might be a law brewing and making its way through the state legislature or other regulatory agencies.
Jordan, if I could just really quickly make a point too, which is, that can be really frustrating just as a practitioner, is comparing the federal to the state. If you're trying to figure out whether a deal has to be reported federally under HSR, that framework's been in place since the 1970s. There are all sorts of resources that you can go to figure out whether a deal is HSR reportable, and it's a conclusion you can reach pretty quickly. Whereas these states, these are all, as we've been saying, new laws, new regulations, and there really isn't that wealth of resources when you're trying to parse language. No matter how well written some of these regs may be, there's at least some ambiguity. And so that injects uncertainty into this as well, is how do you interpret what a healthcare entity is, what control is, other defined terms. And that just adds another layer as you're thinking through these laws, which is figuring out what the law is.
Very, very
Thank you, John. So let's move on to the next slide here, and we're going to talk as we go to the next slide about the implications and considerations for your next deal. So first off, just to finish off our polling questions, do all these changes make you less likely to consider a transaction in 2024? Yes, less likely, no, or C, not sure yet. So as we're thinking about that, there's a couple of things going on that we need to be thinking about here. So first, there was a good question here about states with CON laws and about regulatory measures on new entries like hospitals into markets where there's CON. So the first thing is we're starting to actually see some breaches in the CON wall. So South Carolina, for example, is sunsetting its CON provisions, and that's causing quite a bit of activity in South Carolina, both on the hospital side as well as on the physician side. So we do think that we're going to continue to see that trend of CON laws slowly but surely receding. But where there are CON laws, it's yet another way in which there can be further review. So, for example, we've had a hospital transaction in the East Coast state that's now going through about 365 days now of review for their CMIR CON approval here. And we're negotiating conditions that include pricing conditions for the buyer as to the entire state and their activities there. So when we look at the poll results here, it basically raises the point that there's a lot of ambiguity and ambivalence here about whether or not you should be looking at transactions in 2024 because of all this uncertainty. So let's turn it over to you, Karl, and let's talk about deal planning. In our last 15 minutes here, what would you suggest people do to make sure that they're able to address this successfully?
Great, thanks. So we think about this in a number of sort of overall categories of consideration. And first one we'll just quickly comment on is just general compliance. I mean, how this impacts that. I mean, ultimately these processes are going to require more time, more money. There's going to be more scrutiny overall. And I think what we've seen in a lot of respects is some levels of the compliance work maybe not being so much in the forefront, at least again, some of those areas. Either way, there's no more resolving that you'll figure it out later. To be successful, you're going to have to be contemplating all of this activity in your deal planning and during negotiations and discussions. I mean, deal timelines are already challenging, and add to that, to the complexity of all these new approval processes, multiple states. If you're dealing with a transaction that covers multiple states, as you've been hearing, you're going to have a lot more complexity than dealing with just one. But even in one state, you may have some fairly technical or significant technical challenges. One other, area we kind of like to pick on is unwind provisions, and even something as not, I was going to say seemingly straightforward. Those are far from straightforward. But in terms of the notion of them, thinking about how a particular set of provisions might need to incorporate some of these things, like the timing, the extensive timing requirements that may come of this, or maybe even just the costs associated with these processes, because applicants will be bearing the cost, as we've said in other parts of the discussion. And then something as exciting as the financial analytics around deal funding. I mean, that can get trickier. The more time you have to put into a process to contemplate and apply and get the approvals and things that you need to do, the iterative processes that these will be, you're going to have to contemplate that as you're considering funding a deal with the different complexities already built into those. You're going to have a little more to think about. Can we go to the next slide, please?
Actually, Karl, before you move on,
Yep.
There just was a question about how do deals actually get blocked under these various state rules. And I think you touched on that on your slide, which is that it's the Attorney General's office, typically in most states, that can then bring an action upon the recommendation of the referring agency, like OCA, for example, in California, or OHA in Oregon. So it's the Attorney General that could take that. I know in California, the Attorney General's office, the head of the division, says they're going to be reviewing every single case for the first year that comes through to figure out where they want to step in and how they want to proceed. So we're going to see a lot of interesting activity, both from an economic perspective, but also from a political perspective. All right, back to you, Karl.
Absolutely. Great question. And then, so just again, a few more, or, items related to this. We think about, integration planning, as well as, the previously mentioned opportunity, at least in some areas, to have some information confidential. That's not sort of a uniform blanket concept. There's a lot of uncertainty related to that. But when you think about integration planning, think about the specifics of your deal. How good are you at that planning? But more importantly, now, are you willing to sort of tell the world about it? I think, logic will ultimately reign there, but you're going to have to be very, very careful about how you fill out your applications and what you deem confidential, given the types of questions that we're seeing, especially in states like California, where this is kind of a little further down the proverbial path, if you will. But states are already saying they're going to want to know the intimate details of your transaction. And, I can't help but, you think about how often you've been involved in a deal where negotiations continue up to the 11th hour. Something also to think about. Chris mentioned tolling, the complexity of the application and the completeness of it and the timelines associated with all of that. But think about a situation where you're negotiating up to the 11th hour and you're trying to, determine when you're going to finalize this application. So expect an iterative process for any of these areas. Let's go to the next slide, please. So favorite topic, I think, for everybody on this panel is the unintended consequences. This is kind of where we do a little bit of brainstorming. We certainly don't have, everything on here. This is really just kind of, us getting together as a group and thinking about what might actually happen as part of this. What are some of the implications that not everybody may know about? We think the list will grow. One that I kind of like in this over thing is the first bullet overall is kind of a forced discipline. And we've seen that in California with the DMHC requirements for applying the Knox-Keene license requirements, where organizations have to do such a thorough job with their application that if you think about it in a particular light and use it as something positive, you can actually, we see organizations doing more thorough planning to some degree. So there may be some elements of this, those who do this thoroughly, they may be analyzing things that have strategic implications, and maybe you learn a thing or two about those implications that you otherwise might not have. So trying to identify some silver lining maybe to some of this. On the other side, how many deal implications really pan out exactly the way parties think they will? What we don't know is exactly how the regulatory agencies are going to want to scrutinize post-deal impacts. We're going to certainly be in some states having to opine on what we think those impacts will be, market, for patients, implications to competition, and how is that really going to be monitored if it is going to afterwards. So that's just kind of a couple that I think about. I don't know if others from the team here have comments on this.
I do. I've been out for the last at least the first 2 months of 2024, speaking with a number of organizations across the country that are looking to do significant transactions, that have built up significant capital to make those transactions. And they are avoiding these states with these laws, which is an unintended consequence. I think that's probably not good for the overall healthcare market across the country. And I would speak to those organizations and suggest, instead of avoiding, let's think about maybe engaging with a strategic team of experts like you see here today that can help you develop a strategy to actually be successful in moving that process through some of these state review boards in order to get your investments done, as well as continue to develop your strategic approach. But there's a significant amount of the population out there that have come out and said they're ignoring and avoiding these states from an investment perspective, which is not good. I just wanted to put that out there as an unintended consequence, but also think about when you have a team like you see here today, that experience could be totally different than what you're contemplating.
It's a great point. Should we go to the next slide? We just have a few more listed. Again, it's not a complete list, but those that we have been thinking about as we've been contemplating, reviewing all the regulatory stuff coming out, and these are probably largely unanswerable, but we would encourage, and as Chris just mentioned, bringing in some assistance, but encourage folks to really think through this stuff. These are going to continue to evolve. Not just the regulations themselves, but how you figure out a way to deal with them. Anyway, just like I said, a few more here, that we think there's going to be some volatility for some time to come.
And Carl, I'm really struck by the second point you've got here, because the larger companies out there, the larger private equity funds, they've got capital. They can go through a process that can be 9 to 18 months if need be,
Yep.
and they can bear the cost. But it's the smaller companies, the emerging companies that barely qualify for the transaction thresholds, the ones that could be the next generation competitors, they don't have necessarily the time, the resources, the management attention available to nurse the process through quite a year-long process. So it may very well go ahead and reduce competition. Wouldn't you agree?
No, it's a wonderful point you make, Eric. And previously in the discussion, we've kind of talked a little bit about, again, so California has the ability to request for an expedited review process. Again, we don't know exactly what that means, but financial distress is one of the opportunities that you have to do that. But and in another one of my previous slides, we made a couple of points that might feel a little controversial, and one of those is that will some of this regulation drive some of what it's trying to solve for? And in that particular situation, with smaller organizations being negatively impacted from important business strategies that would have a positive implications, that could absolutely be the case. Let's go to the next slide. We just have a few more, folks. We'll get through these here fairly quickly.
And then we've got a few questions after that, Carl.
Okay, good. Well, we'll just make a quick point here. At the end of the day, we believe deals are going to continue to happen, and they should. It's an important part of sort of the business strategy, the world that I kind of live in. I think we just have to be more thoughtful about all this new process. For more challenging negotiations, do more to keep all eyes focused on the end game and collaboration around these types of issues. I think that's really sort of what would be my takeaway point, is just be very, very thoughtful at the beginning. Make sure you understand the regulatory environment, get the right level of help, and then collaborate with, all parties should be collaborative in this particular process. We're not minimizing the challenges associated with deals. This is creating more complexity, no doubt, but there are definitely ways to navigate this. And I think that, I think that the smart people in the healthcare industry are going to be able to survive. It just might be a little more painful. So I think we've got a couple more slides, and we'll kick it over to Jordan.
Yeah, and I think collaboration is the right word. Creativity, figuring out what the long pole in the tent is, and maybe, for example, whether there's an ability to bifurcate portions of a transaction out, maybe depending on a geography or service lines. It'll all depend on the applicable state and federal regulations. Figuring out whether or not there are interim steps that need to be taken for given the potential for long delays. Whether or not an interim management agreement needs to be put in place. Maybe a loan agreement. Maybe that gets around triggering a state law in one geography, but maybe not another. So just figuring that out. Certainly planning the application process very early. And if you go on to the next slide, essentially, highlight as best you can the good facts associated, with a deal. A lot of these new laws, they are targeting what they consider inappropriate and unsustainable cost growth. Well, if your deal is centered around cost savings, like the shift away from fee for service towards value-based, reimbursement, that's a good fact, and it should be highlighted front and center. And John, just love to get your thoughts just on the final antitrust point.
Yeah, no, I agree with all of that. Also, being mindful of the time and appreciating we have a lot of questions. I'm going to turn it back over to Eric for fielding some of the questions that we've gotten live here during the program.
Great. Thank you, John. Appreciate that. Just first off, if you'd like to download the slides, you're able to do that from your console, and we will also be sending the slides out. They're also from your console. You can download the bios for our speakers today, as well as a joint article that this team has authored. So slides will be made available by email to everybody as a follow-up here. So a couple questions that came up. One question was, if passed, will the Oregon law be effective at excluding private equity-backed physician practice from operating in Oregon, or will the new private equity-backed groups find creative ways around the new law? Well, I've been working with that for a client of mine in the state, and we've already found 2 ways around that. So I think, you just have to make sure that you find lawyers that have got a good sense as to what actually is working in the industry and what's not. And then if you apply models, it should work. So right now, as drafted, there are definitely large holes in it, but don't tell anybody, because we want to be able to use them for everybody. The other question that came up is, if an organization operates in multiple states, is it the revenue generated in the individual state or the overall revenue of the organization that triggers these types of notice or review laws? So Jordan or John, would you like to speak to that?
Both, and it depends. Oh, sorry. Yeah, I was going to say in Oregon, this goes to the fact that it's a new law. It's your revenue in Oregon, but even if your revenue in Oregon isn't enough for the threshold, there's an argument it's Oregon outside of revenue or revenue outside of Oregon also. So unfortunately, the answer is it depends, and both depending on the state. Sorry, Jordan, I didn't mean to cut you off.
No, you took the words out of my mouth. California is at least a little bit more specific to California revenue and assets. But, again, we have new laws, and who's to say that, the next state takes an approach that takes into account not just a statewide revenue or assets.
Right. And we do have,
they keep asking for your amounts in and outside of each state. So you have to disclose all of that information in the transaction.
Very good point. Yeah.
Good point.
Yeah.
right. So when we think about this, if you think about healthcare antitrust review, the first call when a physician or hospital deal happens by the Federal Trade Commission is to the payers. Is this an issue for you in your market? Let's also think about what the regulators are going to do. Who are they going to be talking to at the state level to get the input? And so when you think about this type of law, yes, it's burdensome. Yes, it's expensive. Yes, it's chilling in terms of investment. But there are ways to work this through. And that requires not just saying, hey, tomorrow we're doing a deal, let's get going. But the same thoughtful approach that we have always given to antitrust, we need to give to these statutes now, so that everybody can take a look at how do we best position this. So if what you're doing is going to be improving access, it's going to be serving underserved communities better, it's going to be transitioning to fee-for-service, et cetera, those are things that you want to be part of the DNA, not only of the transaction, but of what you're doing overall from a regulatory perspective. So we're looking forward to working with many folks to go ahead and to help them navigate this new environment, but it's definitely challenging out there. So I'd like to thank Bill Barcellona from America's Physician Groups. He's keeping his finger on the pulse, literally minute by minute, to see whether or not the patient has a pulse. And then secondly, I'd like to thank our friends at Moss Adams for hosting this today and doing such a great job. They're such an amazing accounting firm and consulting firm, and we work with them quite often. And then for Sheppard, Mullin, Jordan, and John, thank you very much for your insights. And thank you to everybody who attended today. If you've got any questions, our bios have got email addresses. We're happy to follow up with you separately afterwards. And we're also happy, again, to share the materials with you so that we can all navigate this fun together. Thank you, everybody, and we'll be in touch. Bye-bye.